Today we'll talk about contracts. I think it's one of the main topics that every business owner deals with, and unfortunately that many business owners have a certain lack of understanding or knowledge. And today's idea is not to get you a contracts course from law school, but more to discuss what we as business owners have to deal with, which areas of contracts we have to pay attention to. I'll cover what, in my opinion, are the groups of the most important contracts for the business operations, how to approach to the review of a contract if you've been provided with one by your clients or suppliers or partners, how to maybe not draft your agreement, but at least to ensure that proper areas of concern are included there. What are, in my opinion, are major concerns when you look through the agreement, and some additional nuances and advice that I can provide in my capacity. Finally, at the very last page of today's presentation, you will get a link to my YouTube channel, where you can find more information about different topics of legal aspects of operating business in Canada, as well as my new project, which is called businessdocs.ca, where you can find templates that could be useful for your business as you grow and as you expand and want to have proper legal documents that you utilize. As we start talking about contracts, it is important to understand that essentially as business owners, everything that we do from the first minute that we leave the house to go to our office and until we get to our homes and turn off our phones or computers or tablets, everything is based on contract. Almost every interaction that you have throughout your days is based on a contract. Our today's presentation is also a contract. It's actually a contract between me and Faith, me and you and everybody else. And the major question that you might ask is, A, what are the contents of that contract? What does that contract imply to each of the parties as their responsibilities, as their rights, as their privileges? From the other side, and that's the main question that we as business owners have to think about, is whether the contract that we have is a enforceable, binding contract for the parties. And that's the difference between a legal agreement, legal contract that you can take to the court in the case of a breach and try to enforce it. And I'll talk shortly today about try to enforce it. And the social agreement where we agree to something, we agree to go to a concert, we agree to carpool to work. And if one party doesn't perform their side of the deal, essentially the outcome is maybe you're less of a friend of mine, but there's no legal implications. There's no ability to enforce the contract on you, either through the actual performance or through the compensation of damages that were caused to me as a result of the breach. And before we dive into the legal components of the agreement, first, I want to talk about different forms of contract. In my opinion, one of the areas that does create a lot of confusion among business owners, because we all are used to having regular contracts that are being printed or written on a paper signed by the parties, and we sometimes just miss or misunderstand or just do not address in the right way the other forms of contracts that also are equally legally binding, have equal legal power, and how to understand them and how to approach these forms. So as I said already, the basic form of the contract is a written form. When we have a written agreement signed by the parties, exchanged in a form of a written document. Now, what you should keep in mind is that in today's age of technological development, any type of writing could be considered a written document, including messaging, including email exchanges, social media platforms where you exchange messages. That, if we can combine it together and come to the essence of the agreement between the party, could be considered as a written contract. I'll show you one of the recent examples from Canadian courts with how you can actually get yourself into the contract where you want it or not. The second form of the contract is verbal. Now, verbal agreement is as valid, as legally enforceable as the written agreement. We can discuss that I want to sell my car, used car, and you want to buy it. We can discuss what the price is. We can agree on the terms of supply, whether it comes with certain warranty or you just buy it as is. And any verbal contract has just absolutely equal validity as any written contract. The only question about a verbal contract will always be is what does it contain and how do you prove your side of the story? Because as long as the contract works, there are usually no conflicts between the parties. Conflict starts when the contract stops working, at which point you want to enforce it. And the question that you will have to ask yourself as business owner, how do I prove? What did I agree to? What I didn't agree? How do I disprove what the other party says? Let's say a client demands from me to make warranty repairs or some additional optional product supply or services, and you have to be able to prove that you did not agree to it. And again, keep in mind, same logic works vice versa, right? So if you agree to purchase of certain machinery, supply for your business, materials, raw materials, you want to make sure that your contract covers what you actually want to receive. Is it just the materials? Is it just the materials and transportation? And I'll talk about the components of the agreement very shortly. Third type of form of contract is significantly less popular, and people speak about less, and that is a contract by conduct. It is probably the most complicated type of agreement. Courts usually don't like to recognize it, but there are circumstances where they will, and where you might be in a position where you want that to be recognized. So essentially, contract by conduct is a situation where two parties behave themselves in certain way recurringly and create expectation of future behavior and rely on this behavior to their personal detriment, at which point the contract does not only come to existence, but also becomes legally valid and enforceable. One of the main areas where this kind of contract becomes relevant, and we actually can see it almost every day among our friends or people that we talk with, it's employment. So if I come to work for someone and that someone is less than organized business owner, so we have what is called handshake agreement. I start working, the employer agrees to pay me certain employment wages, salary, compensation, whether hourly, weekly, daily, monthly, doesn't matter. As long as we conduct ourselves in a certain way for a certain period of time, and it shouldn't be like lengthy, it shouldn't be years, weeks, sometimes months, or even days, depending on the nature of contract, could be enough to prove the nature of the contract. So if, let's say, I agreed to work for you as your legal, administrative, or legal consultant for your business, I come to work, I perform my duties, I help you to draft agreements, to read agreements, to sign agreements, to collect money from your clients, or some other legal and administrative and compliance matters that you might find necessary for a business. At the end of each day, you pay me $300, $500, $1,000, doesn't matter how much we agreed, and we just continue to do it. And based on my reliance on this work with your company, I refuse to accept other offers or other jobs or other projects, which is reliance to my personal detriment. At a certain point, I will be able to enforce this agreement, and in the employment relationship, very fast. And fast, a matter of days or weeks. You don't need to wait months to be able to prove that the employment relationship and employment contract. Actually, because of the problem in the employment area, the today's version of the Ontario Employment Standards Act specifically says that the agreement of employment does not have to be in writing, because the law, the legislators, they understand that in many cases, those agreements were not in writing. People usually just started working, received certain pay, and continued for many years. So to prevent employers or other parties from saying there's no agreement, therefore there's no employment relationship, the law specifically says you don't need an agreement. So as I already said, by conduct, it's when parties sometimes that never saw each other, never communicated with each other, but simply conducted themselves in a certain way, repeatedly, create a contractual relationship. Each of the parties can rely on that relationship and can enforce it if something happens and the other party just forfeits their responsibilities. Another point important for today's discussion is there are no formal requirements for the agreement. And what it means is that if you can see, lawyers usually write it on a nice paper in nice structured form with introduction, whereas ABC, therefore CDE. That is essentially not necessary from the perspective of the contract law. Contract could be written on a napkin during a restaurant meeting, and if it's detailed enough, and if it actually indicates the meeting of the interest and intentions of the parties, it could be a valid agreement for any purpose whatsoever, including for the enforcement of the court. It could be exchanged, as I said already, by SMS messages, WhatsApp, whatever other messaging platform you prefer. And there's no formal requirement. As long as we can prove that person A communicated with person B and they agreed to certain terms of the contract, and one or two parties hopefully started performing that contract, the contract is there. You don't need formal signature. You don't need formal paperwork. Any type of exchange will work. But again, always keep in mind, if something goes wrong, how do you prove what was the content of the contract and what did you agree for? Or what do you expect to receive in exchange for your performance? Sometimes it could be payment, sometimes it could be vice versa. You perform and you expect to receive the payment. So what are the legal components of the agreement? So those portions of the interaction that take it from the social environment into the legal binding sphere of agreement. Essentially, every contract would include three major components. Offer and acceptance, they're relatively simple to understand. There are lots of complications that lawyers and judges created throughout the years, but generally, in a simple form, it's I offer you to buy my used car. You agree to buy my used car. There could be a little bit of a confusion or argument. What happens if I say I offer you to buy my car at $5,000 and you say I agree to buy your car but at $4,500? So which portion of that exchange is the offer? Which one is the acceptance? But technically, every agreement nowadays is relatively straightforward from this perspective. We would have an offer, we would have an acceptance. Sometimes offer is expressed, sometimes it is implied. Essentially, if you ever look at the legal documents of the stores that you go to or the website sites that you buy from, usually they would say that placing the product on the shelves is not an offer, it's just placing it there. So essentially, when you take the jar of milk, you do not accept the offer of the store to buy it from them, but you actually create your own offer to the store to buy it from them when you come to a cashier, and they accept your agreement in exchange to the payment. And exchange to the payment, this is a very important part because that is what makes a contract or agreement legally binding, and that's the consideration. So if you think about it, let's go to watch a movie. Okay, I agree to go to watch a movie. It's a valid agreement that contains offer, let's go to watch a movie, and acceptance. Yes, I agree to, let's go to watch a movie. But as long as that exchange does not contain a consideration, something which was determined by the courts as something of value, not necessarily comparable to the value of the agreement, as long as there is not exchange of physical or very substantial non-physical value, such as reliance, there will be no binding contract. Now, if you ever signed a mortgage agreement, a mortgage paperwork, and you actually bothered reading the documents that you sign, you would pay attention that at the loan agreement, it will always start with words that in consideration of the parties exchanging between themselves $1 or $2 or $5, doesn't matter. You will see there a very, very insignificant amount mentioned as exchanged between the parties, while you take a mortgage of $1 million. And ask yourself, what's the role of those $2 that we theoretically exchange or virtually exchange between ourselves. I gave it to the bank gave it back to me. So no one lost anything, no one gained anything. What's the point of those $2 in the agreement? And the point is specifically that create a binding nature before the bank gave you even the money. So by this virtual exchange of $2 between the parties, we have bound the agreement into binding, legally enforceable form. Without that, it is not binding, and you cannot force it on the other party in the case of a breach. Once again, in these exchanges, in these discussions of offer, acceptance, what is important to keep in mind, especially in today's day and age of online, of electronic markets, of almost every business being present online, you have to understand that your website, content on that website, offer of services, offer of products on that website, especially if the price is attached to that offer, would be considered either as an offer and acceptance, depending on the definition of the transaction that you provide. And I'll speak today about the website terms and conditions, and it's important as a kind of contract that you enforce on every person who enters your website. Definitely everybody who uses it to purchase something, make an order, or communicate through your website. If you, let's say, maintain or facilitate some kind of platform, forums, exchange of opinions, social media platforms, all those will need proper definition of the contractual relationship between you, visitors, between themselves during the interaction, and some other relevant points. So we discussed all these three areas, all of these three components. Now, as I promised, here's a little bit of a bonus information. Those of you who've seen it, I'll explain. Those who didn't, very recently, I think in Saskatchewan, a court has been dealing with the question of a supplier writing to the client, I agree to supply you whatever product for $60,000 plus, and they exchange it by messaging platform, I think SMS or WhatsApp, and the buyer sends him thumbs up. Supplier sees that thumbs up and understands, or maybe to the supplier's personal benefit, thinks that that was an agreement of the buyer to actually buy. That thumbs up meant, yes, I agree, the acceptance, right? At that point, the supplier started preparing and shipping the product to the buyer. When the buyer got the product, the buyer refused to accept it, saying there was no agreement. I don't have to pay you. I don't want to accept. I'm simplifying the example. And the supplier had no choice but to go to the court. So the position of the supplier was that thumbs up that was messaged to me by the buyer was essentially a signature of the buyer on the agreement and the expression of the consent, at which point our intentions and our goals have met, and we've created binding agreement. And once I've sent the products, I've created that consideration. I acted to my personal detriment. I paid for the transportation. I packed everything. I sent it to the buyer. I complied and I fulfilled my part of the agreement. Now the buyer should fulfill its own part of the agreement, essentially to pay me for the product. And the court decided, yes, indeed, that was a valid agreement. Thumbs up was a valid and unequivocal expression of consent of the buyer to accept the terms of the agreement and to order the product. And the buyer was ordered by the court to pay that $60,000+ to the seller. So be careful and understand the exchange of the messaging, emails, whatever platform again you use. Now that we understand the technical, let's say, side of the agreement, let's speak about the main issues or main areas of concern and information that we as business owners should look and should verify that the agreement contains, should pay our attention to, and ensure that certain areas are included depending on which side of the agreement we are at. So first of all, parties. As trivial as that could sound, there are many agreements that have failed, or vice versa. There are many people that have been found liable for the performance of the agreement, despite them actually intending and wanting to do that. So with regards, first of all, with the names of the parties, always verify the spelling always verify the identity between the person that you contract with and the name or of the person or the organization that is listed on the contract. Because in many cases, contracts failed to be enforced at the court because the plaintiffs were not able to prove that the name that is written on the contract and the actual defendant that they went after is the same person or the same organization. So make sure that the names are properly spelled. Verify before you sign agreements, especially large agreements, that make sure that you get the ID documents either of an individual or the organization, especially in the situation where you send your products, so you provide the services, valuable ones, because then you can find yourself sending the products somewhere to a person who is not a party to the agreement. Essentially, you could lose your products and not get paid at the same time. Second important portion, and that is connected to one of our first presentation in this series, and that is make sure that the person and the party that is listed in the agreement, that is essentially the party that you wanted or intended to be a party to the agreement. And this logic works both ways. So if you are a party that wants to enforce the agreement, right? You supply, let's say, a service, and you want to make sure that someone is responsible and someone kind of guarantees that the agreement will be paid. You would want to add an individual, company's owner, company's director, whoever executive manager or officer that you were communicating with as a party to that agreement. So essentially at the header of the agreement where it says the parties, you want an individual name to be added next to the corporate name, because it is much easier to get paid from the individual that has a house, a bank account, a physical existence, than from the corporation, especially in the small and medium businesses that might have nothing. And then even if you're successful after you spend lots of time, money, resources into chasing the other party in enforcing the agreement, and the court determines that, yes, you're entitled for damages, how do you get the money from an empty corporation that has nothing? And many more sophisticated businesses use these tactics against us, small, medium businesses. I've seen a lot of contracts, especially of utilities companies, their business model that exists already for some years, where they average your utility bills, especially for restaurants, for high utility cost types of businesses. They essentially would come to you and tell you, we will average. So you will pay, let's say, instead of monthly bill based on your consumption, you will pay us based on whatever average amount that we decide. Usually these agreements are going for 5, 7, sometimes even 10 years, where you take the responsibility and you undertake to pay that averaged monthly amount for the whole duration of contract, which is essentially averaging the fluctuation of your bill. All those organizations, a lot of times communications organizations like Bell, Rogers, working with small, medium businesses, will want to put your personal name as a party. And the idea is exactly the same, to make sure that they can go after you if the contract doesn't work out well, or you want to terminate it earlier, or you just sell the business and the new buyer doesn't want to use that same service as you did. So make sure that the names are spelled correctly, and also the parties are exactly the parties you want to be there. Now, if you ask yourself where your name should be, because you are the business owner and you are signing that agreement, it should be at the very bottom of the agreement where the signing page is, and next to your name, your position should be written, and preferably under that, a simple statement saying that I have the authority to bind the corporation. So this combination of your name at the very end as a signing officer, your position within the company, and I have the authority to bind the corporation, creates the presumption and creates the factual situation where you are signing not on behalf of yourself as a private individual who later on could be on the hook for the performance of the agreement, but as an officer of the corporation, leaving the corporation as the one responsible for the contract. And again, we discussed how important that could be in the case of liabilities. We probably will repeat this presentation. So if someone missed 3 months ago, be in touch with Faith. We'll publish the new series soon, and you can attend and listen what's the difference between operating your business as a private individual or as a corporation. Next concern is, what do you sell or what do you buy? And again, as trivial as it might sound, there probably most of the lawsuits, this is the biggest area of concern in the contract law is specifically that. So what is that is being bought? What is that is being sold? First of all, describe the product. Describe exactly the product that you're selling. So I'm selling my used car for $3,000. But what if I have two different used cars standing behind me? You look at one car and I speak about the other car. What if I sell you my service, but you think that in addition to my service, I also sell you the result of my service? So I frequently prefer not to call myself a consultant, because I do not consult people what to do. I do for people. I provide them with the services. But a lot of times people that do operate consulting businesses, they would almost certainly avoid the situation where they're also responsible for the results, because a lot of times the result is depending on your personal performance despite the consulting that you receive. With sale of products, what exactly the product contains. Does it contain the packaging? Does it contain the installation? Does it contain the operations, warranty, extended service? Nowadays, when you buy a car, a lot of dealerships will offer you 1, 2, 3 years of free oil exchange. But what happens if you are the dealership? And what happens if the neighborhood dealership does offer the oil exchange and the person who comes to you expects that you will do the same? Now, you have to make sure that your agreement specifically mentions what you sell and what is included in the price. Very important topic, again, being missed by many business owners is the warranty. And the question is that included in the price, and what warranty is? And as business owners, and sometimes as consumers, we have to keep in mind that warranty itself is not defined in any law. There's no warranty act or anything even similar to it. So the lawyers among us will argue and will say, yes, but there are certain rules under which we can draw the warranty into the agreement because it was expected, it's natural, it's a common way of doing business. That is true. But as business owners, do you want to deal with it? Do you want to chase the supplier to make sure that the supplier complies with the warranty terms, some artificial understanding that you might have to the warranty terms, and vice versa? Do you want to be chased by your clients? So make sure that the warranty is properly defined. If you purchase the products, make it as wide as possible, as long as possible. If you sell products, especially more complex products, machinery, automation, electronics, make sure that you define the warranty within what you want to be included in the price. Now, with electronics, by the way, a lot of times we would deal with the question, does that include the replacement? So also be careful with the definition of what warranty is. And if you'll pay attention, most of the larger companies, including the largest electronics companies, they will always keep this door open. And that's what I suggest to my clients as well. So be able to decide whatever is better for you at that moment. So either you repair the product, you replace the product, or you pay back the cost of the product. And at certain points, different solutions could be more preferable or less preferable to you. And make sure that you're the one who decides. Now, extremely important area of product supply rather than services supply is the delivery. I've added the Incoterms here, and those who do not know what it is, it's a very interesting and strange kind of organization. So Incoterms is an international not-for-profit organization, the whole purpose of existence of which is to publish the terms of delivery of products. And there are about 20 of them. And some subcategories more complex, but if you ever purchase products from overseas as an import to Canada, you would pay attention that the bigger suppliers would include in their supply contracts or sales contract such mentioning as the products are sold DDU or X-Works or CIF. All these abbreviations, all these terms apply to the terms of supply. And terms of supply, they have multiple implications. So first of all, the question of where the product was supplied. And the important part of that question is technically who's responsible for the transportation of product from the manufacturer to your facility. Sometimes it could be from China to Canada, and it could cost thousands of dollars. Sometimes it could be from Bonn to Markham and cost a couple of hundreds of dollars. But this way or another, you have to understand who's responsible for it. Second question is when the product is being supplied. And here the question is less of a time-wise. I'll talk about it later, but more of a implication at which point of time that product stops being under the ownership, control, and responsibility of the supplier and becomes part of the ownership, control, and responsibility of the purchaser. And again, approach it from both sides. As a suppliers or as a purchasers, we all act under both hats every time. So that is an extremely important topic, because the question of when implies the question of responsibility. And that is the reason why Incoterms exists, because in a larger transaction, the question of at which point you as buyer become responsible for the product could imply the main question: what happens if the product is getting lost or damaged? Now, it is especially important in the case of shipping, in the case of maritime, when you use actually sea transportation, when it includes lengthy periods of storage. So let's say your supplier delivers to point A, the product stays there for 3, 4, 5 weeks until it's being picked up by the next transportation company, is being supplied to you. What happens if the product gets damaged? It drowns in the ocean, the container falls off the ship, the warehouse burns down. Who's responsible to cover the damage? And bottom line, who's responsible to buy and pay for the insurance? These are very important topics. They're covered by those terms taken from Incoterms guidebook. So let's say X works means that you get the product as soon as it exits the gates of the production facility. So if your supplier is located in Manchester, UK, the moment that the skid with the product exited the gate or was loaded on the truck and truck exited the gate, you are responsible for the product. So when you buy the product, you have to contact your insurance company and buy insurance in addition to the cost of the product. You have to incorporate it. CIF, let's say, would stand for cost insurance rate, which means that the supplier is responsible for the product until it gets all the way to your location. Some other definition will also include the question of who's responsible for duties. That would be the DDU. So duty is something else paid. All these terminology you have to learn as business owners when you deal with import-export transactions, and when you want to define at which point you become responsible, and you want to define either, let's say, if you're a supplier, do you include the cost of insurance in the price of the product, or do you add it on top? Which again, your agreement should provide and stipulate. Otherwise, I could think that the $1,000 for that machine includes the insurance and delivery, and you can think that the $1,000 is the before insurance and delivery. And the whole conflict and confusion, which can destroy your relationship with me as a customer, could be resolved by simply including it properly and expressly in the agreement. But you have to think about it. You have to address these issues. So let's continue. Price. Think about the previous slide and just include everything after the names of the parties into the price, and make your decision as business owners, whether as a purchaser or as a seller. What do you include in the price? So does it include the delivery? Does it include installation? Does it include insurance during the delivery? Maintenance, warranty, replacement, training. I work with lots of suppliers of unique technologies, of autonomous drones, of production CNC machines. There are very few people who can take that machine, install, make it work, and know what to do with it. So most of my clients would also provide training. Now, very recently, I was requested by my client to deal with the question of, okay, we were requested by the government of Zimbabwe to provide them with a fleet of drones for the agricultural investigations and some photography and delivery of medicine. They also asked us to provide training. The problem is part of the drones or the training drone or equipment got stolen. Some of the training personnel were not allowed to get into the country, and the government was very dissatisfied and wanted the money back. And I asked them, what did your agreement say? You can only imagine the confusion on the faces, but essentially we figured it out. We updated the agreement, and you should keep in mind that if you produce and supply similar products time over time, your agreement should be not fixed in stone. You have to learn from your mistakes. You have to try to, of course, to prevent them in advance, but if they happen, work through them and then update your agreement to make sure that they do not repeat. So price is an important portion. Again, could be a very, very confusing and conflict generating topic. So make sure that your agreement with regards to price specifically is very detailed and well describes what it is that we pay for and what is included, what is not included. So for suppliers, a lot of times it will be important to list what is not included in the price as additional options or additional payments. For us as consumers, we of course would tend to make sure that everything is included in price. But in some situations, let's say we can come to a supplier and say, I know myself how to install, how to train, how to launch the equipment, reduce the price. So all these interactions, they're very flexible, and we have to be just aware of these aspects. Unexpected circumstances. This is a very painful topic, and the reason for that is because it is absolutely not defined, again, in any law, any act, anywhere. And so in order for you to be able to protect yourself from unexpected circumstances, and the logic, by the way, works both ways. Sometimes you want to make sure that if unexpected circumstances prevent you from performing the agreement, you're protected from a delay or inability. From the other side, as a consumer, you want to make sure that notwithstanding or despite unforeseen circumstances, the contract is being performed. A lot of times what happens is that something that happened with your supplier in other part of the world could delay the supply of the materials or raw products or whatever product that you want to resell to you here in Canada. Now you have the next step in that chain. So you have the consumer that is actually expecting to receive it in Canada. Now in Canada, nothing happened. So that, I don't know, like forest fire or strike or war in some country in other parts of the world that delayed the supply might have nothing to do with your relationship with your next step in that chain, next link in that chain, and your client can come to you and demand the product which wasn't supplied to you due to unforeseen circumstances on that side. Now, if both agreements do not contain proper definition of unforeseen circumstances, of force majeure, or whatever your rights and whatever your authority to amend the agreement in those situations, you will end up being on hook towards your client in Canada for delayed supply. Now, what if that client has the next client in a row who's expecting to receive the products maybe produced by what you supply, and so on and so forth. So you have to be aware and thinking about all these different circumstances that outside of our control and define them in advance, at least generically in the agreement. So as you can see, mostly we refer to it as a force majeure. But in addition to definition of force majeure, again, pay attention, it's not defined anywhere in any law. You cannot go to any specific act in Canada and find what force majeure is. Especially when you're a supplier, be sure to include as wide definition as possible. Usually we would include the natural disasters, the governmental actions that were not foreseen in advance, societal changes, and whatever else we can add there. So after COVID-19, of course, pandemic, lockdowns should be included always in force majeure provisions, because in many cases, the courts decided that yes, government locked down the market, but it did not release you from performance of your obligations under certain agreement, especially under the employment contracts. And of course, include the option to change. So if something happens and it's outside of your control, you want to be able to come to your client and tell them, look, I understand there's a delay, but this is outside of my control, and here's the agreement, and under this agreement, I can change the terms, so I can extend. I would always suggest in specifically, especially in a time-sensitive agreements, if you see that it goes for a long period of time, let's say for a month, and your supply is being relevant for a very short period of time, of let's say 2 weeks. If you see that your force majeure will prevent you to fit within those 2 weeks time frame, make sure that you have the right to cancel the agreement without any, of course, implications. Term. So how long the agreement will work? It is important to understand when it starts. It is even more important to understand when it ends. It is important to define the right to extend. Now, starts easy, ends a little bit more complicated, especially in the service-based agreements. So at which point the contractual obligation of you to supply something ends. So if you come to me to get legal consulting or let's say compliance consulting for a company, at which point whatever you paid for to me has exhausted the scope of the agreement, and I have the right to come and ask you to pay more, or you have the right to say, okay, no longer need it, if it's, let's say, hourly based. So here's the list, in my opinion, of main agreements that every business will be dealing with. Of course, business transaction, that is the essence of your business. You sell something, you buy something, you resell something, that would be your agreement. Think through it, create a couple of templates that cover most of what you do on your daily basis, or purchase them from someone like myself or lawyers, and make sure that you adapt those agreements as an ongoing concern. Second is the employment and contractors agreements. I include them in one section. They're different. It's just not the topic for today's conversation. Make sure that, and I'll talk about employment agreement in a moment, what to make sure to include there, what are the important areas of the employment agreement. Agreement with your suppliers, same like business transactions, but from their side, make sure that your interests are well protected. Keep in mind that except for when you're dealing with large, extremely large organizations like banks, insurance companies, most other agreements are negotiable. Website, usually being, again, overseen by many business owners. Your website is not just face of your company, it's actually the nature of your company in many cases. If I can go on your website, I can get information about your products, get pricing, or if, let's say, you facilitate, as I already said, social media platform, or forum or communication, or I don't know, place where people can find suppliers, service providers, employees, workers, all these types of relationship. There's a contractual relationship that happens inside your website. The moment I get into that website, you want to make sure to define proper the terms. So let's say in a social media platform or kind of social media platform that you decide to launch, the question is, who's responsible for me posting their derogatory, discriminatory, or some hatred statements on the platform? Are you personally liable? And if you think that you're not, you have to go and look at the terms of use of Google, Facebook. You will see those hundreds of pages of terms of use that specifically are there to protect those platforms from the liabilities, which means initially liability exists. It's just you have to opt out of it or waive it. Privacy, very important, especially for businesses that do collect, and most of the businesses today collect information. We also set up cookies in many cases that have been installed in our clients' or visitors' computers. Make sure that you provide provisions of what you do, how you do, what your information collect, what you do with that information, whether you sell it or don't sell it, especially if you plan to sell it, which is not a good idea from the business perspective. But if you do, make sure that you define it specifically, what you sell, how you sell, to whom you sell, because that is what is required also by law in Canada, but also you want to make sure that your relationship with clients are properly defined. These are special agreements, but again, many people don't think about them in advance, and unfortunately end up being in not as good situation as they would have been. NDA, non-disclosure, non-compete, non-solicitation. These agreements are important for businesses, especially If you operate some kind of unique types of businesses where you expose your employees, contractors, suppliers to very unique kind of information or custom information that could become very valuable for them, and they could decide to abuse it for their own benefit. Many businesses that deal with development, so businesses that work with innovation, development, patented technology, you want to make sure that you protect. And again, this is topic for a completely different presentation of intellectual property and its protection. We already did this session, and again, if you'll express more interest in it, we can repeat it again next time. Now, employment agreement. What do we want to make sure that is included in employment agreement? And I'm starting to increase the pace because we're reaching the end of today's presentation. So first of all, you must have an employment agreement, although the law says not necessarily, but my opinion, without that, you will be at a 100% losing situation. As business owners, we have to keep in mind that the legal system in the employment field is built, and in my opinion, crooked against us. Everything that you will be dealing with in the employment field, you will be fighting against, and you will be trying to prove. There's no presumption that you can use. The whole system is built to protect the employee, and at the end of the day, it ends up to being many employees do use it to abuse or to gain the benefits that you did not intend them to provide, at least this way. So you have to define specifically what is the position, what is the salary. Now, be careful not to define the position too narrow, because the moment you want an employee to perform some additional tasks, the employee might say, no, I did not agree for it. If you want me to do additional tasks, I want to get paid more. Now, it's easy to think I'll fire him for that, but what if that employee already works for you 5, 7, 10 years, and then the cost of termination will be huge. And again, this is topic for another conversation. Define probation period, which is not defined in law, nothing in employment. So in Employment Standards Act of Ontario, the word probation is used only once, where it says the probation period or employment during probation is exactly the same like employment at any other time. So you have to define what is probation, what are your rights during probation, what are employees' rights during probation, what is expected. Option to change the terms, as I said, keep it as wide as possible. Change of location, change of conditions of work. Now, keep in mind with COVID, many people moved into remote work. Now, afterwards, the employees refuse to get back into the office. And if your agreement does not say that you can enforce it, tough luck. You will be dealing with lots of lawsuits that will try to prove that you forcing them to come to office is a negative change in their terms of employment, and they can consider it as a constructive dismissal. So essentially, they will resign and you will pay them termination compensation. How to terminate the employment? Be careful with that, because with the termination of employment, the courts usually use that provision. Many of my clients want to include termination with cause. I don't want to pay anything. What if he steals something? Now, in recent years, to my opinion, that is absolutely wrong approach. That approach that destroys the economy. But that's what the courts do. They look at the termination with cause. They say this provision is not something that we want to accept, and therefore the whole agreement is being thrown into the garbage. All the protections that you put for yourself, the courts disregard them, and you end up dealing with the employee paying as much technically as the court decides to give against you. Layoff. Sorry, before I jump into the next topic. It is important to include layoff. There are lots of current situations where during COVID, employers laid off their employees because the market was shut down. And the court says, we do not care. If you do not have the right to lay off your employee under the employment contract, then your layoff is the breach of the employment agreement, and you have to compensate the employee, essentially to pay the employee the salary for the whole period of layoff, which again, in my opinion, is ridiculous. Layoff is included in the Employment Standards Act. But remember, we fight against the system in this case. System is crooked against us as employers. And I'm sorry if any employees are listening to us, but this is the nature of the environment today. Protect your business interests inside the employment agreement. Remember, non-disclosure, non-compete, non-solicitation, all these provisions are not covered at all in the Employment Standards Act. So law does not protect your business from anything. Your employee can come to work to you, can collect all the information, learn all the techniques, learn all the strategies from you, and next door open competing business. And unless you have anything that prevents the employee from doing this, tough luck. Keep in mind with non-compete caveat, and I have to add it here to the presentation, is that as of last year, including non-compete in the employment agreement that continues to act after the end of the employment agreement is illegal. Don't do it. So if you want to include non-compete in your employment agreement, definitely speak with me or anyone else, lawyer that you rely upon, and make sure that they review and create proper structure to non-compete if it actually makes sense. Better rely on non-solicitation because that is still enforceable, although I already dealt with lawyers that think that it shouldn't be. But again, that's the nature of where we live. Ownership of intellectual property is very important. Every business creates intellectual property. Again, we have different presentation about intellectual property, specifically trademarks, copyright, patents. You have to make sure that you protect your business. You have to make sure that you define that the intellectual property being created and produced by employees belong to you. If you did not provide it, it will belong to the employee, or best case scenario to you and to employee, but essentially will open your business if it grows, expands, and succeeds to future lawsuits of the employee for compensation, for fees, royalties, whatever they created. So define what is included in intellectual property and that you are the only owner, and your salary is the payment for the creation of that intellectual property. Special provisions, speak with someone who will provide you proper consultation on that, but make sure that you have at least reviewed your employment agreement before you start implementing it, or as you move forward, do it at least once a year, once every 2 years, because courts go crazy, rules change every time, and again, to our detriment as employers. Contractor, I just will go through that. You will get these points from the PDF presentation that Faith will distribute to you. Again, very similar to employment, but we want to make sure that the contractors do not become your employees. Again, topic to a different presentation, as I already said. Our next is the website agreements terms of use. There are a couple of things that you should include. Very important, almost to any business that operates website, especially for businesses that sell their products or services through website. You should include the terms of use. So every visitor of your website must submit to those terms of use. And the theoretical or virtual structure is built in a way that you say, it is you, visitor, your responsibility to go and to check those terms of use. If you didn't check them, it's only your fault. But by clicking on my link and being on my website, you agree and accept with all those terms of use. Now, if you just start a business and you don't have budget for someone like myself to do it for you, that's okay. I always say, go to your competitors, direct competitors, larger, preferably competitors, see what they use on their websites. Don't copy paste, but redo it for your business. See the logic behind that document, apply it to yours. Okay, with regards to privacy, we as business owners, owners of the websites, collect a lot of private information. At least it will be IP address. Many times it will be login information, email addresses, contact information, names. Make sure that you define in your privacy policy what you collect, why you collect, what you do with that information. That is required by law, by the way, and how you will be protecting this information from unauthorized access. Same thing with cookies and trackers is covered by the same privacy legislation. Make sure you cover it. Define what you sell through the website if you want to sell anything. Who's responsible for the actual sales transaction? So if I'm buying from your website an item, who's responsible for the payment processing? Because what happens if the payment doesn't go through, or vice versa? What happens if my credit card is being charged 10 times more than what I intended? To whom do I go? To you as a website owner, or to payment processor as the one who was processing the transaction? And if you define it properly, it will reduce a lot of headache from your business operations. And many times, let's say my clients that supply same product, those guys with drones. What we've created a separate link in the website that provides terms of warranty. And so when you sell a product, the only reference in the product would be the warranty is listed there. It gives you two options. First of all, it is much easier to put lengthy warranty in the website rather than print it on a paper, which will increase the cost of your product. But also, you will be able to adapt, adjust, and change the warranty as you move and as you learn, and this will apply to every buyer before and after. Now, as I already said, with forums, we want to make sure that we define the rules of communication. We define our right to remove people from the forums. Without that, will be very difficult, or will expose us to lawsuits, to complaints, negative publicity on the internet. We want to be able to reduce or remove certain negative opinions, whatever is unacceptable by our terms of use. We should define what we can do. It's our website, but unless we define it there, someone will have to essentially come and make up the terms of the contract. And sometimes it could end up not in our personal benefit. Waive responsibilities, important to almost any business, unless you actually want to be responsible for what you do. It is very important in a forum kind of environment because in forums, people speak to each other. We do not control many times those channels of communication or exchange of information. And we don't want to end up being responsible for visitor A hurting the feelings of visitor B, and the visitor B then looks at us as a facilitator of that communication and says, you're responsible for my feelings being hurt. Now it's very popular and could lead to many negative legal implications. What are additional issues that we should look into the contract? Disclaimers. You will pay attention that lots of larger companies include lengthy disclaimers. Make sure that you include, not too lengthy, but at least the basic one. Disclaim the responsibilities you don't want to be responsible for, liabilities you do not want to be a part of the agreement. Website, age of those who are allowed to visit, age of those who are allowed to purchase. Keep in mind that age could be very complicated. Again, different topic for different presentation. But essentially, if a person is underage and a person buys something from you or enters into contractual agreement with you, that agreement you cannot enforce against that person. But once that person becomes grown up, the rules change. Now, that agreement might be enforceable against you by the person or their parents. So be careful. Provide proper definition. If you enter my website, if you sign here, if you check mark here, you acknowledge that you're 18 years and older, which makes you the acknowledgement applicable, and then you will be able to enforce the agreement against those people. Application of common law, again, speak with a lawyer. Common law is a very complicated field of law in Canada because it's not written anywhere, it's not published anywhere. These are rules that judges created inside their decisions of different files, different courts, and it for untrained person will take years to find out what actually the rule is. On the website, very important, define the ownership of images of copyright, especially on forums, because or on website that allow people to exchange ideas and exchange information. Who's the owner of that copyright? By the definition of copyright, and again, different presentation, but copyright is created by the fact of creation. Artistic creation includes painting, music, any type of art, photography, and text, including the source code, including any communication between people, books, of course, songs, anything that is written, there's a copyright behind it. Now, who's the owner of it? Pay attention what Facebook says, pay attention what Twitter says. They usually want to keep the copyright to themselves so they can use it in the future, and they don't want to pay the visitors the royalties if they decide to use it. And vice versa. When you buy or use images on your website, make sure that you purchase them properly with a proper copyright license, that you get the right to use, and you owe nothing to whoever created that image, because otherwise, if your business explodes and becomes something worldwide famous, those creators will remember who created those images and will want to get their royalties from this large business. So make sure you define these rules. Notification of recordings, audio, video, keep it especially in communication with your clients on your premises. Keep in mind that from the legal perspective, the recording that was made without one of the parties being aware is inadmissible at the court. So if you want to record a conversation and you want to make sure that that recording could be used at the court if something happens, the other party knows about it. You cannot use concealed recording. Same thing with your premises. Put a sign. Everything here has been recorded, video recorded, so you can use it in the future. Jurisdiction, pay attention, define proper jurisdiction, not just from the perspective of which law applies, but also from the perspective of which court has the jurisdiction over the conflict. And when you draft an agreement, you can define it. You can enforce. You can bring people to Toronto. So let's say if your client is located somewhere else, Brazil, Jamaica, Bulgaria, and a conflict is there, you want to be not just protected, but also you want to be able to manage the conflict with the less or the least legal costs. And most of the time it will be beneficial to manage it in the place where you're located, because you will spend less on the lawyers and international movement and stuff like that. Final chapter today is the enforcement of agreement. I'll speak very shortly. I'm already stealing 6 minutes of your time. I'll steal 3 more with your permission. First of all, keep a proof, keep a trail of communication. As I already said, exchange of messages, emails is good enough. If you want to enforce the agreement, or if you want to be protected against enforce of agreement, works both ways. You want to be able to prove what happened. You want to be able to prove what was the communication between the parties. You want to be able to prove who was responsible under the contract or by the communication of yourself. So we already spoke today about the meaning of documents. Any type of exchange will work, as long as you can prove it, as long as you can prove that you received it from the relevant party. Mitigation of damage is extremely important topic for contracts. Technically, it is a basic rule that says every party to the contract must mitigate or reduce its damages to as low as possible. Essentially, it means that you cannot sit tight when you're innocent party and I'm breaching the contract. You cannot sit tight and wait until the whole contract has been exhausted and the damage grows to some unreasonable proportions. The very classical example is the landlord that rents out an office space. I lease that office space for 3 years. After 6 months, 9 months in business, I understand that it doesn't work for me. I don't want it anymore. I cannot sustain it anymore, and I leave it. Now, the courts are very clear, and the rules of law are very clear in that landlord cannot sit until the end of the term and then come and sue me for the whole 3 years term of the lease. The landlord must act reasonably, promptly, fast to find a replacement tenant. And then I will be responsible only for those actual damages that my breach of contract, my inability to continue the rent caused to the landlord. So that period of time that was spent while the premises were unoccupied, plus the legal cost, administrative cost of onboarding the new tenant. That's it. If the landlord will take its sweet time, you will be able to come to court and say, I'm not paying for that. Reasonably, the market was positive to find a substitute tenant within a month. So I have to pay him a month plus a couple of thousands of dollars of switch of documents, of document fees, legal fees, and that's it. So same logic will work in the opposite way. All that brings us to the point where we have to come to the court with clean hands and say, I am the innocent party. I just want that agreement to be enforced, completed, performed, payment made, and move on. And as you already could have realized from my presentation today, I'm not a fan of legal system here. In most of the cases, small, medium businesses will not benefit from going to courts. In my opinion, the legal system is lengthy, costly, too stressful, and there are always risks that we do not always see and realize because we tend to see only our side of the story. There's always the other side of the story. The process will cost a lot. Usually it takes between 18 to 36 months to get to the decision. And there are enough researchers in this world to prove that both parties, the winning and the losing, are always dissatisfied by the outcome of the court proceedings. In many cases, the legal fees would outweigh any benefit that you will get from the court. So my question is, before you rush into the court, ask yourself, why do you need it? But even before that, there's an option to define in the agreement proper arbitration clause that will significantly reduce the cost of legal proceedings. You will find an arbitrator, and that process is much faster and less demanding from the legal fees and the process itself. Which essentially completes our today's presentation. So thank you. These are my contact information, details, email, phone number. If you have questions, preferably send me an email. I'm not always available on my phone, and it will be more difficult to get a hold of me. Emails, I do my best to answer them within 1 to 2 days. This is a link to my YouTube channel. You can either use the QR code or just search on YouTube for Business in Canada Do It Right. You will find there at least 40 different videos on the different topics of legal aspects of doing business in Canada. And this is my new project, businessdocs.ca, again, QR code. And here you can find so far about 100 of different templates, some of them free, some of them at pay, but they will help you to organize your business and operate it in a protected way, which brings my presentation to an end. Thank you.